Namaskar. Good morning to everybody. Welcome to the today class of the revision, that is the interpretation statute. Those who are going to sit for the regular examinations in this week that I dealt in my last class. That is the language canons. That is the two which I completed it. And yes, the participants are here. And yes, please read what I posted on the screen so that I could know that you are hearing me and I am hearing you. Yes, please read that what I posted on the screen so that you could know. I could know that you are hearing me and I am hearing you. Hari Babu, please unmute and give me the answer to my question.
Good morning, sir. I am
Very morning. Yes, that is a good thing that I know that you are hearing me and I am hearing you. Now I can proceed without any hesitation. And these are the two things which I covered yesterday. That is the secondary rules. For instance, that yes, Egyptian generis, meaning of the same kind. I did it in the last class. Noceta Rossosis, meaning a word is known by the company it gives. That I dealt in my last class. In this class, that I would like to deal the third maxim, that is the language canon, which is said to be the, yes, here I will make it out. I'm dragging it. Yeah, this is the third thing which I want to deal in this class. That is expressio in alterius, where the express mention of the one thing excludes others. There is the equivalent terminology in English language. There is expressio and unis exclusively alterius is the rule of language. This statement talks about one or more things of a particular class, eliminate all other members of the same class. For example, if any statute refers to the lions and tigers, it only refers to lions and tigers, and it will not include leopard, jaguars, or any other wild animals. So that was the thing what this maxim says. Suppose if it says the statutes or if any maxim says the lions and tigers, it only refers to lions and tigers only, but it will not include leopard and jaguars, even cheetah also in it, and other wild animals. Those are all carnivorous wild animals. So that is exactly the what the maxim says. The R versus Secretary of State for the Home Department, the ex parte crew. In this, the applicant, the 23 years old illegitimate daughter born in Hong Kong of a Chinese mother and father, and assumed to be by the court to be English, law would be applied on the 24th November 1974 for an entry clearance to the United Kingdom as a student. Inquiries revealed that her intention was permanent residence and the application was refused on the ground that an illegitimate child, she has no claim to be legal daughter under the Immigration Act of 1971, even though the father is an Englishman. Now, because this is a legitimate child, for an illegitimate child, as per our rules are concerned, the mother will be taken into consideration, but father paternity will not come. So this decision is upheld by an adjudicator under the Immigration Appeal Tribunal. The word the parent within the meaning of the Immigration Act of Section 2, subsection 3 and Clause A of the Immigration Act 1971 did not include the father of an illegitimate child. Only mother having the right of the child, that to be the valid under the Immigration Act of 1971, but not the father. So this canon of the statutory interpretation is used, that is expressio unjust est exclusively alterius, and father was excluded, the mother is included. Because of this maxim, that is the reason you will say this maxim also can be useful, where they say father, where they say mother only entitled for the custody, so mother will be taken into consideration. That means it is father is excluded. That is the maxim which is said in this case law versus R versus Secretary of State for the House Department ex parte crew. It is clearly mentioned in that way. The another case law that we will see R versus Harris, that is Harris bits of the end of a woman's nose. So Harris, he bits of the end of the woman's nose. The prosecution alleged that the bite was included in the stab and cut or wound, but that actually the implied that the same instrument might be used Some instrument will be used for the bite and stab and wound, but here the case law say bite, and the bite with the mouth, it will not attract the provision of the stabs and cut where the instrument can be used. So one thing is excluded means that is excluded. One thing is included means the other thing is excluded. Yeah. Please unmute, because I'm getting the sounds. Yeah, whenever you want to speak, you can speak by unmuting it, but other time that you can mute it. Yes, please mute it. Yeah, this implied that some of the instrument must be used over there for the stab and wound. That is the reason. So, if anything wound caused by the teeth or hands, it will not become under the definition of the stab or cut. So, the injuries would be by the instruments only considered as the language rule expressio unjust estes visibly ulterius. So the defendant was found not guilty because the defendant made the bite with the mouth. It will not attract the stab, cut or wound, the definition. So he will be excluded because of this maxim or by this language canon. R versus inhabitant of Sedgely. This is another case where the statute raised the taxes on the lands, houses and coal mines. They say tax would be there on the lands, houses and coal mines. These are the three things added. So that means the court held that it did not apply to the limestone mines because they say coal mines, but they did not mention the lime mine. Hence, when is included means the other thing is excluded. It means here the limestone mines were not specifically mentioned, nor did the statute suggest it would apply to other types of mines. So that will be excluded. When something is included over there, that is the house, lands and coal mines, that means the limestone is excluded. So this maxim will not be applied for the limestone, and there is no tax for the lime quarries, that the limestone's mines. That is the point. The another case like the Tempest versus Kilner, the court had to rule whether the statute of the fraud 1677 applied to the sale of the stacks and shares. The act required the contract for the sale of the goods, wares and merchandise to be evidenced in writing if they were above a specified value. The court decided that stacks and shares are not covered by the act as the specific words goods, wares and merchandise, which is clearly mentioned, only goods and wares and merchandise could be included. That means stocks and shares were included. So these canons were not followed by the general words. So in other words, this will not be strictly applied in the event that the act mentioned that the words listed are illustrated by the use of words includes. For example, as this suggests, there may be other items which may apply. So that is, when you say includes, means only those things should be taken into consideration, but the other things could be excluded. So that is the actually the thing where, yes, can anyone unmute, can say that, yes, sir, we are hearing you and you can continue.
Continue, sir.
Very good, very good. That is a very good thing. So next canon is, our language rule is redundo singula singulis. It means, this is a Latin term by referring each to each, referring to each phrase to each expression to its corresponding object. So in simple words, redundo singula singulis means when a list of words has a modifying phrase at the end, the phrase refers only to the last. It is the rule of construction usually in distributing property. So where there are a general word description following the record of a particular thing, such general word are to be construed distributively. And if the general words will apply to the same things and not to others, the general words are to be applied to those things which they will, and not to those things which will not apply. That is to say, each phrase or word expressio is to be referred to its suitable objects. The best example of the redundo singula singulis is quoted from the Watson's lexicon. If anyone, I repeat, if anyone shall draw or load any sword or gun, the word draw is applied to the sword only, and the word load is to gun only. The former verb to the former noun and the later verb to the later noun, because it is impossible to load a sword or to draw a gun. And so of the other application, different sets of the other words are can also used for the redundo singular singulis principle concern the words distributively. Where a complex sentence has more than one subject and more than one object, it may be the right construction to provide each to each by reading the provision of the distributively and applying each object to its appropriate object. A similar principle applies the verb to their subjects and to the other parts of the speech. So let us see the another example, what it says about the redondo singular singulis. So a person will say, what he will say, I devise and bequeath all my real and property to be. Suppose if A says, I means A says here, A devise and bequeath all my real and personal property to be. The redondo singular singulis applies, it would be read as, I devise my all real property and bequeath all my personal property to be. So, devise will come to the real property and bequeath will come to the personal property. So, that is the actually the thing. Since the word devise is appropriate to use for the real property and bequeath is appropriate to word used for the personal property. This rule of language is used when the use of words distributively, where a complex sentence has more than one subject and more than one object. It may be the right construction to provide each to each by reading the provision of the distributively and applying each object to its appropriate or corresponding subject. A similar principle applies to the verbs and their subject and other parts of the speech in this manner. Let us see one of the case law where the Koteshwara Vittal Kamath versus K. Rangappa Baliga. There is a case law where the redondo singular singulis applied in this case. In this construction of the proviso, where the article 304 of the construction which reads like this, provided no bill and amendment for the purpose of the class B. Here they say, provided no bill and amendment. So now we are concentrated, bill refers to which one and amendment refers to which thing. So provided that no bill and amendment for the purpose of the class B shall be introduced or moved in the legislature of the state without the previous sanction of the president. So it shall be introduced or moved in the legislative state without the previous sanction of the president. It was held that the word introduced applies to bill and moved applies to the amendment. So that is the reciprocal subject and to verb and subject to the another verb. When there are mere subjects are there and when there are more objects in the form of verbs are there, which will apply to whom that redundant singular singulis can be used over there. But here in this case law, where the word introduced applies to the bill, because the bill is introduced generally, and moved means the amendment, the mood apply to the amendments. So from the one Lok Sabha to the Rajya Sabha, so that we will say the mood for the bill. For the amendments we can use it. So that way the redondo singular singulis can be used over there in the language canons when you want to make it clear what is to be drawn and what is to be loaded. So here the above case law, in one of the example, a sword can be drawn from the scabbard and the gun can be loaded because of the ammunition in the holes of the revolver. So that was the thing where we can make it out. So let us see the another canon, that is the language rules, which are said to be the secondary rules. Those are the at res magis valet quam peret. That is the fifth one. By using this reasonable construction could be done. The maxim at res magis valet quam peret is the rule of construction, which literally means the construction of the rule should be give effect to the rule rather than the destroying it. So better a rule would be there, it should be an effective one rather than destroying it. That is when there are two constructions possible for the provisions, of which one gives effect to the provisions and other renders the provision inoperative, or further it gives effect to the provision is adapted and later it will be discarded. So which provision will give the meaningful one, that could be used over there, which gives the provision gives the discarded one or destroyed one, that can be disregarded. In generally, it starts with the presumption in favor of the constitutionality and prefer a construction which embarks the statute with the competence of the legislator. But it is to be noted that when the presumptions of the constitution fails, then the statute cannot be rendered valid or operative accordingly. So the landmark case of the Indra Sahane versus the Supreme Court struck down the state legislature as it was a violation of the constitution and ultra violate for the legislative competency, because at any time that case law say the more than 50% would be there will become an ultra virus. That is the reservation concerns. So where the statute says about the plant and machinery, again another example will say where you can use the plant, where you can use the machinery. So suppose the serial number 1 plant is there, that means a place where the industrial or manufacturing process take place. That is the plant. And the second meaning serial number 2 is concerned, that is the plant means put a seed or a bulb or a plant on the ground so that it can grow. Then which meaning would be taken into consideration? If you take the plant meaning serial number 2, seed or bulb or which grows, that will not fit, so as to make the first meaning which is given in the serial number 1 by using the maxim at res magis valet per comparate, then the former which gives effect to the provision is adopted, the later can be discarded. Here in the plant, when you say which causes the environmental pollutions, at that instance we cannot see that it is the industrial or manufacturing, but it cannot be used as a plant or a bulb or plant. That meaning which we cannot cause the industrial pollution, but rather it can make the air to be fresh by swallowing the carbon dioxide and in the photosynthesis and releasing the releasing the oxygen O2 in the photosynthesis. So that is the meaning that we have taken it by using the at res magis valet comparate. A deed has to be read as a whole and effect is to give its parts. Unless a part of the deed is so inconsistent, the rest of it no effect to be given to it. The law intended to save the deed if possible. This is sometimes expressed in the maxim that is the at res magis valet comparate. If a reasonable construction, the intention of the parties can be arrived, and yet that intention carried out consistently with the rule of the law, the court will take the course. That also observed in the Narayan Prasad Vijay Varghia versus CIT. In that case law, it is also very much clearly expressed. While interpreting the provisions of the law, one is intra-vires, another is the ultra-vires. At that time, only one would be followed which is useful and other would be destroyed by the following the above maxim, which should be followed or which should not be followed. That is clearly said in the Corporation of Calcutta versus Liberty Cinema, AR 1965, Supreme Court 1107. There also this same intra-vires and ultra-vires can be used over there. And what is useful or what is not useful can be taken into consideration by using this maxim, that is the at regis magis valet comparate. So I believe that you got some point regarding what is what. Which is the meaning can be used for the meaningful one and give the clear cut for the utility, rather than taking the other meaning for that one which will be discarded, which will be useful and which cannot be give the justice to the party. So when the two meanings are there, the one meaning which gives the sense can be used over there. The another meaning which gives the absurdity and the uselessness are with the null and void, that could be discarded. So that is the whole idea behind this maxim. Yes, again I want to say the participants, yes, I believe that you are following what I am saying. Yes?
Yes, sir.
Very good. So the above maxim which clearly mentioned which is the right meaning for that one which is useful to the to deliver the justice to the party, that can be used over there, rather than that thing which is leads to the absurdity, the next meaning which will not lead to the justification, that could be discarded. That is what the at res magis valet comparator it clearly gives. That is which gives effect to the provision is adapted, which gives effect to the provision is adapted, and the later which gives the nonsense meaning or absurd meaning, that should be discarded. So that is the whole gist of that maxim. So let us see the sixth, contemporanea exposito esto fortissima in lege, meaning the contemporaneous exposition is the best and the strongest in law. It is said that the best exposition of the statute or any other document that which it has. So, contemporary exposito esto optima et potissima in lege means the best way to construe a document to read it as it would have read when made. So, in which sense it is made at that time, that meaning can be read as a whole. The doctrine of the contemporaneous exposito is well known for the interpreting the statute by referring to the exposition it has received from the contemporary authority, whoever it should give way, where the language of the statute is plain and unambiguous. It is considered to be the best exposition of the statute or any other document is that which it has received from the authority which has a competent enough. The words of a statute would be construed in such a manner it has been held by the person creating such a statute in a true sense. It is considered as if they would have been constructed as the day of the statute was. Suppose at the time when the construction of the statute there is no cyber crimes. Only crime is there. At that instant, what is given at that instance, that meaning will be taken into consideration, but not cyber. But now, suppose if you want to include the cyber crime, if there is a provision would be there, any other crime, if the blanket provision is there, where we can use this cyber crime also, if the blanket provision is there in that aspect. The rule is that the statute must be considered in the light of all the words that it has been in statute were construed, followed logically, and the court has to be held. The maxim aims at the expressing the words of an act will generally be understood in the sense which they bore when it was passed. So when it was passed, what is the meaning? What is the thing that can be used over there that will be taken into consideration? Let us see the origin of this one. Where the maxim is based on the principle as stated by Salmon, the essence of the law lies in the spirit, nor its letter. For the letter is a significance only as being external manifestation of the intention that underlies it. So actually the spirit will be taken into consideration, but not the letters. Interpretation is considered to be the way of defining or the true sense of an enactment by virtue of the recognizing the natural and ordinary meaning of the words in any enactment. In other words, it is observed that the process of ascertaining the finding out the true meaning of the words used by statute. The court over the year laid down many principles for interpretation, so that the interpretation does not amount to the arbitrarily. The maximum contemporaneous exposito est optimo et potissima in lege, which means the contemporaneous expression is the best, most powerful law is force. So what is the intention of the party at the time that they took the contemporary expression at the time that will be followed over there rather than the other thing. Illustration: if any document of any statute is meant for a special group of the people, they are represented by a particular word. The word will include the group of the people until unless otherwise mentioned. So references we will see the A.P. Rangaswamy versus State of Karnataka and others. It was observed that when the public premises is leased or sold or mortgaged to some person is to be done only to the provision of the law. Leasing the property of the government, municipality or corporation, which is a public property, shall be on the basis of the distributive order. Persons of the society from the different walks of the life should be given an opportunity. When the premises is to be granted to a particular person and he has to utilize the same, shall also give an opportunity to other person also who are in queue. One should not use it the premises of his own choice if it is a public place. When a public place, when a person is using it for a place, for instance, entertainment like the slings and the slopes are there, we should not use from morning to evening, but a chance should be given to the other people also who are there in the queue. The equal opportunity will be given to them. When an agreement is entered into between the parties to a terms, agreement prevails over the unless it is alleged that the agreement itself is a fraud, etc. When there is an agreement between the parties, at the time the parties only could enjoy it. When the agreement is not like that, for instance, the public place which can be utilized by the public at large, at that instance only one person can not exploit it, but others should be also given the chance to use that the premises. So here the premises in the sense for the public, for the everybody can enjoy. If the premises for the exclusive for a particular person who is purchase the ticket, means that person who is having the license to enjoy it can enjoy the premises. So the period of the occupation is the 4 years, 11 months, and said period has expired. If it is the lease cases, if there are any continuation is there, the same can only on the basis of the renewal or license or permission or by open expression could be done. So if the lease period is over there, at that instance, the owner is having the reversionary right, and the person who is holding the lease is over, then he will become a trespasser on his the land. Even though before that the lease is there, he was not a trespasser. But when the lease period is over, then the person who is enjoying the property, he become a trespasser. Because the lease period is over, the owner will get the reversion. So no such permission is granted or renewal is made under these circumstances, then the petitioner approach to the court, which is quite contrary to the agreement entered. The maxim conventio et modus vencum, that is vincant legem. That means a contract and agreement overcome the law, and conventio privatum non poteste publico juris derogere. An agreement of a private person cannot derogate from a public right would apply in all four to the cause. Under these circumstances, the petitioner failed to accordingly they are liable. So, if a premises would be used by the public, then the public at large would be having a right to over there. One cannot exploit it because other people are in use. Suppose the premises would be for the private purposes, then the license holder who has taken the license or the person who has made the agreement, such a persons only can enjoy it, but not the public. So it depends on the premises where it can be used over there. So the premises used for the private purposes or public purposes. And what is the intention of the parliamentary at the time? If the lease is there, it's the private purposes. If the public place is there, the public gardens are there, that is the public purposes. So in that view, that it will be taken into consideration. But let us see the another case law, ABC, Laminate Private Limited versus AP Agency Salem. The Supreme Court held that the law of contract can only be prescribed at a limiting principle within which the parties are free to make their own contracts. So when the law of contract is there, they do have the party to have their own contract, they can make the limits for that one. That an agreement enforced by law is a contract, yes, that is definitely, because the social agreements cannot be enforced in the court of law, so it is not said to be the contract. That the agreement which is proposed to use the jurisdiction of the court absolutely is contrary to the public policy. So if any agreement would be there, they cannot be such a condition that no court will have the jurisdiction to enter in such a case law. So that is against the public policy, that is also will not be done. Then the fourth one is that each of the citizen has the right to have his legal position determined by the ordinary tribunal except by the courts in contract where there is an arbitration clause which is valid and binding upon the law, and when the parties to contract agree to such a jurisdiction to which a dispute in respect of the contract shall be subject. Yes, if there is the arbitration, what would be there in the agreement would be there. Yes, the arbitration is a binding on the factor because the agreement itself gives such a scope for the arbitration. Then the next fifth point is that the contract which can propose to destroy the right of one or both of the party to submit the question of law to the court of contrary to the public policy and void on a pro tanto. Suppose if your contract would be there which destroy the question of law, at that instance, such a contract which is against the public policy also will not be binding factor. Then the sixth point, the parties cannot be contract whose the ordinary courts from their jurisdiction. So there should not be any contract within the both party that no court will having any jurisdiction to entertain such a case. Such a agreement could be void. It is against the public policy and such a wide agreement cannot be made. If the party should seek the agreement by to take the law out of the hands in the courts, it put into the hands of a private tribunal without any recourse to all the courts in case of the error of law, then the agreement is to be extended contrary to the public policy or void. So what is a void? What is against the public policy? It clearly say that if an agreement which is against the public policy or for the moral justice or for the illegality, then such agreements are void. Then the eighth point is that under section 23 of the Contract Act, consideration of the object of the agreement is lawful. So if the lawful agreement should be there according to the section 23 of the Indian Contract Act, unless it is opposed to the public policy. It is clearly mentioned under section 23 that every agreement of which the object of consideration lawful is only void. Unlawful is void. If that object or consideration is unlawful, then automatically certain agreements are void. And the 10th point is, hence there can be no doubt that an agreement to lose absolutely the jurisdiction of the court will be unlawful and void, being against the public policy. That already said. If any court is having any right, yes, there definitely the court is having a right because jurisdiction one cannot take it out because jurisdiction will be already might be made according to the parties are concerned which they agree. by that one it can be made, but not the parties cannot make such a thing that there is no jurisdiction to be there for no court could entertain such a case. Such a agreement would be there that is avoided because it is against the public policy. Let us see the another is the Ma Binda Express Carrier and another versus Northeast Frontier Railway and others, where the court held that it is well settled position of the law that as per the series of the decisions rendered by the Honorable Court of the Supreme Court of India in the matter of the award of the contract, the government and its agency have to act reasonably and fairly in all the points of time to the extent tender has an enforceable right in the court, which is competent to examine whether the aggrieved party has been treated unfairly or discriminatorily against the detriment of the public interest. So, if any agreement will be made which is against the public policy or detriment of the public or against any one of the existing law or against the Grannam or the constitution, such an agreements are wide and issue, or it is available on the decision of the party if the agreement is made between the two parties by the fraud, by coercion, by any other means, or the subject matter of the agreement would be against the public policy or against the government or against the object or against the section 23 which is made, the object is at that instance the agreements are such a wide. So here the point what I want to say is, in the contemporary situation, if any agreement is made, in which aspect it is wide, in which aspect is avoidable, depends upon the context. By that one, the contextual meaning would be taken that what exactly the sixth maxim says that refers. So we have thrown light much more on that. What is that maxim says? That contemporaneous exposition fortissima in lege, meaning the contemporaneous exposition means what is the contemporary exposition would be there, where it is the premises. Either it could be used for the private purposes or it could be used for the public purposes. With that exposition, the contemporaneous is to be best and the strongest in law. That can be taken into consideration. It is said that the best exposition of the statute or any the document is that which it is have the meaningful and useful purposes. That meaning can be used over there, because this is also one of the canon or the language canon, we can say, are maxims, or we can say the secondary principle which one may use it when the cases are disposed by using such a canons the time necessary comes. That means if any person will comes to the court, he should not go with the empty hands. Some one way in another way, what is the intention of the party and whether such a statute can be used, whether such a statute can be applicable or not applicable, and the court will definitely will go through it and they will decide it. Yes, this meaning will be useful and this canon can be useful to decide the case law. But I don't think that it is there. Judicial activism is there where the court, where the judges will take the law into their hands. No. Judges will not take the law into their hand, but the judges will interpret the law and give the meaning of it. Yes, by using such a principles, general principle, that is the primary principles, by using the rules, and the secondary principles, by using the language canons, that is the maxims. By that one, the judges will come to the conclusion that this is a justification will be given to the parties. So these are the things which will come into the picture where these canons can be used over there. Yes, if any other thing that you would like to ask, you can ask me. Because of these canons. Why these canons, language canons can be said to be as the secondary rules? Yes, anyone? Can anyone give the answer to my question?
Sir.
Yes. Yes, please unmute and give me the answer. Yes, give me the answer. Unmute and give me the answer.
Sir.
Why these canons can be used? That's my point.
Sir, to interpret the statutory definition, sir, in the contextual and contemporary.
Very good. Which could be included, which could be excluded.
Yes, sir.
మా మొగల్లా మాట అన్నారు అనుకోండి అంటే అర్థం
ఆడోళ్ళు ఉండకూడదని
అంటే అది ఎక్స్క్లూడెడ్ అన్నట్టే కదా.
Yes, sir.
Yes, because these canons can be used over there to say that what is the intention of the parties, where they excluded, where they included, what is the same side, what is the other things, at that instant that can be taken into consideration. So these are the canons which are very much useful. I am sure that definitely one canon will come in the examination. Take it granted. Either in the form of a short question or in the form of a long question. If it is the short questions are there, yes, because the marks are given less, because overall that you are supposed to do the 5 questions, I believe that 2 questions from the short questions and 3 questions from the long questions. Long questions carries how much marks? Because the 12.5, 12.5, 25 marks will be the short questions. Then the 25 into 25 into plus 25 means 75 marks for the long questions. Subject to the correction, please tell me what is your view?
Thank you, sir.
What is the pattern of the examination?
Is it 2 hours is less time, I think, sir.
See, 2 hours. You have to compact your answer in a such a way the 2 hours should be divided among the either the 3 questions or 4 questions or 5 questions, depending upon the nature of the questions. Always time factor is a very great factor. Please maintain it. A person who will be time management knows it definitely will score the good marks. Never spare 1 hour for one question. And sir, 1 hour I wrote some 20 pages, sir. Of it all with a 1 hour question, one question which carries the 15 marks or 25 marks, he cannot give more than 25 marks. Moreover, it is not a mathematics to get the 25 out of 25. So that's why divide the time and the time over, then skip the question, give the space, go to the next question. Then time is over because you can specify equal question, equal proportionately you have to give it. So if the time is up, then you leave the space, then go to the next question. If the time is left over, there definitely last question you cannot do justify that much, when the time will be more for you. Then you can turn on to the first question where the gap is in that the gap you can fill up it so that you can score the good marks. With this, I would like to wind it out because the techniques also I have given to you to how to answer the question and what the time should be there, and the time division is very much important for each question. Suppose the 5 questions are there and 20 and 120 minutes are there, then you divide it by 120 by 5, then how much will come depending upon that one you can spare the time. If the time will goes excess, go to the next question immediately without wasting the time and attempt all the questions. At least by attempting, the examiner will definitely will give the marks rather than attempting the 3 questions out of the 4 questions you have to do it and you lose directly the 1 question marks which is awarded to that. Is it correct or not?
Yes, sir.
Yeah. So with this, I would like to wind it out. My today class and tomorrow class again we will see in the same timings because the evening that you have the exam, and that is the reason that I don't want to make it out. And regarding the another canon, because the 2 questions which I give it, what are the 2 questions from where we can make it out? For each one that I have given the questions. So for each one, there is a 2 questions I made it for you. From that questions that only that I am dealing this today's class. And today is the questions comes in the interpretation of statutes. Yes, we will go into it. I will show you what are the 2 questions for each statute that I made it over there. Yes, then that in the tomorrow class that we will go through the other questions. Yes, 2 questions I came over there. Yes, 2 questions. Yes, 2 questions. And today that I dealt it, what are the general principle of interpretation statute? The unit 1, question 3 we dealt it, and question 4 in the today class I dealt it. There is the language questions, canons under the general principle of interpretation. Then we will deal in tomorrow class at least this either interpretation of the penal statutes and statute of taxation. These are the strictly construed over there. The penal statute and the statute of the taxation, that is the unit 3, question number 5 we will deal it tomorrow class because generally the question may be asked what is the strict construction of both the penal statutes and the taxation statutes. Later on, I don't know when the exam would be there. Still the time is there for the examination. Is it or not? Yes?
Yes, sir.
Yes, then
Yes,
we will. In which date this exam is there, interpretation of statutes?
9th, sir.
Oh,
9th.
still we do have it. Then we can complete it because we in your hand. Because today is the 4th, tomorrow is the 5th, 6th, 7th, 8th, even 9th also I will take the class because 9th day I will take the class and the evening that you have to make the examination. Is it or not?
Yes, sir.
Yes. So up to 9th I will continue it. I will see that. But tomorrow discussion is regarding the fifth question. What is the interpretation of the penal statute and the statute of taxation under the interpretation of statutes, which is the question 5. I will deal it tomorrow class. Please inform the other people also to enjoy the class and participate in the class, get the benefit of the class, because those who are absentees also they can enjoy it. But when you take the participation, because the live is having the more impact than the other thing which we can only watch and not watch exactly. And of course, both the thing you can make it, but the live is more impact than the recorded one. With this, I would like to close my today's class. Then thank you once again for the patient listening. Then we will meet you tomorrow by the question number 5, and we'll be back
Thank you, sir.
tomorrow. Then the people, those who are
Thank you,
absent,
sir.